Good morning, everyone, and welcome to this webinar that marks the launch of a very important policy brief setting out key takeaways for negotiators and other stakeholders who are going to be engaged in the elaboration of a new treaty on the protection of persons in the event of disasters, which I understand the UN General Assembly has committed to concluding by the end of 2027. So the theme of the policy brief and of today's webinar is an exploration of what international disaster law can learn from experiences in responding to global health emergencies, and in particular, what lessons we can take from the recent negotiation of the pandemic agreement, which was adopted in May last year, for the future negotiation of the International Disasters Treaty. And we're especially fortunate to be joined by Mark Eccleston-Turner, who has done a lot of work, including with BIICL in the past, on the pandemic agreement. So I'll leave it to our wonderful panel to discuss the subject matter in detail. I merely offer as a high-level general reflection that there are clear parallels between global health law and international disaster law, both areas that at their heart, at their core, are fundamentally about preventing and relieving human suffering and addressing situations of humanitarian crisis, be that a pandemic or a hurricane. And I really hope that the policy brief and this webinar helps to build the bridge between these two areas of law and practice, and that we can foster greater collaboration and communication between experts in these fields, so that lessons are shared, and so that ultimately humanitarian assistance becomes ever more efficient. Say some words of thanks, firstly on behalf of me and BIICL. We're absolutely delighted to have been included as partners in this important project. And thank you to Therese O'Donnell, who's on the panel, and Steph Schweitzer, who's watching at home, and Miroslav Sadowski, and all from the University of Strathclyde, who've been instrumental in leading and steering this project from the very beginning. And thank you also to Paul McKell and his colleagues at the FCDO for also partnering in this project. We're also extremely grateful to the Economic and Social Research Council for funding this project. So thank you very much indeed. I'm delighted to introduce today's speakers. First, I'll introduce them in order that they're going to speak. So I'll begin with Mark Eccleston-Turner. Mark is a reader in global health law at King's College London and an academic fellow at the Honourable Society of the Middle Temple. His research specialism is in the field of international law and infectious diseases. Mark has also worked as a legal consultant to the World Health Organization and advises numerous governments on matters of international law and pandemics. And in 2020, he was made a Fellow of the Royal Society of the Arts in recognition of his work on access to vaccines. We're then going to hear from Giulio Bartolini, who is full Professor of International Law at Roma Tre University and a member of the board of the European Society of International Law. In the field of international disaster law, his activities include acting as the editor-in-chief of the Yearbook of International Disaster Law, working as a legal assistant to the International Law Commission's Special Rapporteur on the protection of persons in the event of disasters, and providing scientific report to the International Federation of the Red Cross Disaster Law Programme. Giulio is the author of numerous publications, including the Routledge Handbook of Human Rights in Disasters, as well as an article in the International Review of the Red Cross on a universal treaty for disasters, remarks on the International Law Commission's draft articles on the protection of persons in the event of disasters. We're then going to hear from Therese O'Donnell, who is part of the core team of this project. Therese is a professor in the law school at the University of Strathclyde in Glasgow. She obtained her LLB from Strathclyde Law School and then undertook postgraduate study at Cambridge and the University of Dublin. Therese has a particular expertise in public international law, human rights law, and international disaster law, and is a regular reviewer for the Yearbook of International Disaster Law. Very wide-ranging research, including much research for BIICL, covers history and critical geography. She has also published extensively in the disaster law field, in particular with respect to an affected state's right to refuse aid, duties of cooperation, coincidence of disaster assistance and security issues, and the question of whether there is or ought to be an emerging legal duty to offer aid in the event of disasters. She has also considered what international disaster law reveals about our understandings of solidarity, vulnerability, how disaster law reshapes, recontours the role of NGOs, and whether there's a role for mediation in disasters, and how international disaster law itself might be reconceived. More broadly, Therese is interested in how disaster law casts an illuminating light on the foundational structures, principles, and institutions of public international law. So thank you very much to all our speakers. We couldn't ask for a better panel on these issues. Very fortunate that they've joined us today. We have the luxury of not being overly pressed for time, so the panelists will be glad to know that I will not be strictly watching the clock and timing their interventions. That said, I think we broadly say, if we envisage the presentations to be in the region of 15 to 20 minutes each, in order to leave plenty of time for questions from our audience. So on that note, I'll hand over to our first speaker, Dr. Mark Eccleston-Turner, please. Thank you very much.
Thank you very much, and thank you to Anthony and BIICL for having me, and also huge thanks to Professor O'Donnell for inviting me and her work on this report, and also a huge thanks to Dr. Stephanie Switzer, who I'm stepping in for today, who is one of the authors on the report, which I played no role in writing, and I'm just here to riff on about global health law in general, but lots of the other work was done by Steph. So I'm going to give a little bit of a sort of general overview of the pandemic treaty, where it came from, and what can be learned from it. And I'm in particular going to emphasize what can be learned from the process of the pandemic treaty negotiations, if not the substantive content itself. And I think it's really interesting that the General Assembly has started the process of negotiating a treaty around disaster law, because in general, treaty law is on the wane within international law. There is a general trend against using hard binding treaty law to solve problems. So it's really interesting that we've got these two major developments occurring somewhat concurrently in New York and in Geneva to create new treaties, and also quite ambitious treaties to address quite fundamental issues, as Anthony said in his introduction, about saving lives, having a humanitarian focus. So the pandemic treaty negotiations are being hosted in Geneva in the World at the World Health Organization. Their negotiations started just at the tail end of COVID-19, and they're very much a response to the perceived problems with the international legal framework for pandemics that we saw play out during COVID-19. Now, unlike disaster law, global health law has actually got an extraordinarily long history of attempting to use law to resolve problems. The international legal framework, which was in existence at the time of COVID, is around 150 years old. It finds its origins in the International Sanitary Conferences from the 1850s, and it has evolved over time and morphed into what's known as the International Health Regulations. Now, the International Health Regulations were updated several times throughout its history, in the 1940s, in the 1960s, and a major reform process in 2005 after the first SARS outbreak in 2003. And this was a hugely ambitious program of reform at WHO. And through a number of different events, it was tested and found to be wanting, not just COVID-19, but also Ebola in West Africa, Ebola in the Democratic Republic of the Congo, Zika outbreaks in Brazil, all of which highlighted the shortcomings of the international health regulations. But the major shortcomings were really highlighted during COVID-19. And I'll just run through what some of those problems were, and I think we're all fairly familiar with them. The first problem was searing inequality between high income and low income countries in their capacity to respond, and also their ability to source medical countermeasures. We saw widespread vaccine nationalism, particularly by the wealthiest countries, which led to a situation where high-income countries had far more doses than we actually required in order to immunize our populations, leaving little to no vaccines available for low and middle-income countries. We saw temporary recommendations, which are the process whereby the Director General of the World Health Organization makes recommendations about state conduct during an outbreak. We saw that these were widely ignored by governments. The Director General tried to balance the public health response with the economic response around things like trade and travel restrictions, border closures, vaccine nationalism. The Director General made recommendations around each one of these things, which were largely ignored by high income, by lots of countries around the world, but in particular high income countries who shut their borders, had forced quarantine requirements put in place. So we really saw the normative authority of the Director General of the World Health Organization, but also the normative authority of the international legal framework that was in place, sort of crumbling before our very eyes. Some of the other problems were much more systemic. And during the pandemic, myself and a colleague, Gianluca Berci, wrote a paper in the International Yearbook of Disaster Law, talking about the international health regulations and the response to COVID-19. And one of the things that we highlighted is that there was an overemphasis on preparedness, on what the health system needed to look like within a country, about your capacity to detect events and run sequences and have bed ventilators and so on and so forth, and not enough emphasis placed within the regulations on the response itself, of how countries needed to actually respond. Once the Director General had declared COVID a public health emergency of international concern, we largely stopped talking about the international health regulations, which is the very point where you need a structured, formal, legal response of how to manage an outbreak. So that is the sort of process of where this came from. Member states were, we have a long, rich history of 150 years, international health regulations. They failed during COVID-19. Member states wanted something new. Unfortunately, they didn't really know what they wanted. It's fair to say, which I'll go on to talk about. But nevertheless, they formed an international, what's called the INB, the International Negotiation Body, to negotiate a treaty. And one of the things that they did was set a very ambitious timeline. So they started the process in 2021. And they said that they wanted to present it ready for adoption at the World Health Assembly in 2024. Now, aside from the international health regulations, which aren't actually a treaty itself, isn't actually a treaty, it takes a very odd status within international law, which we won't go into right now. WHO has only ever negotiated one treaty in its history, which is the Framework Convention on Tobacco Control, which was adopted in 2003. And that took over 12 years to negotiate. And it largely bases itself on an acceptance of the fact that cigarettes are harmful and we need to stop people smoking, is essentially what it sets out to do. And we had 60 years worth of evidence to underpin this idea that, yes, smoking is really harmful for people. We need to do something to meaningfully address it. So even something as quite straightforward, which was not particularly contentious amongst any member states, we need to stop people from smoking because it's so harmful. That still took 12 years. There were problems about some countries trying to influence the negotiations to be protectionist of industry. Industry was very heavily involved in trying to influence those negotiations. But by and large, we were trying to do something which countries all agreed on what the problem was and what we needed to do to fix it. That is not the case with pandemics. The diagnosis of what went wrong during COVID-19 and how we fix it differed significantly within these negotiations. And that's one of the first things that I think international disaster law can learn from global health, is have a very clear vision of what you are actually setting out to achieve. Because when it came to the negotiations of the pandemic treaty, there were vastly different ideas about what the problems were and therefore what the solutions were. Member states all could agree that they wanted a treaty. They just didn't know what they wanted in it, and they didn't know what problems they were trying to solve. High-income countries, pushed in particular by the European Union, were trying to solve the problem that they perceived of low-income countries in general don't have good enough surveillance systems in place. They're not detecting disease events early enough, and they're not sharing information quickly enough, and they are not adopting a One Health approach. They are not thinking about the entire ecosystem and where zoonotic spillover events, diseases coming from animals in particular, happen and occur. Their animal husbandry practices are not good enough. They're not up to Western standards. We need to bring them up to Western ideas of what good animal husbandry looks like. We need to improve their surveillance systems. We need them to share more information, was by and large the vision that a lot of high-income countries had about this treaty. Low-income countries, on the other hand, viewed the fundamental problem as being one of equity. And it's really interesting, as I'll go on to talk about that, they used the language of equity. They wanted to address these huge inequalities that existed between high-income countries and low-income countries in their ability to respond, in particularly their ability to procure medical countermeasures, vaccines, medicines, diagnostics that they needed when they needed it. They viewed that as the fundamental problem that they wanted to solve. And the problem was that each one of these visions of what this treaty was to solve was in conflict with what the other party wanted. So low-income countries viewed what high-income countries wanted as being too dogmatic, too top-down, too prescriptive of their animal husbandry practices, too prescriptive of their surveillance systems, and therefore an intervention with their sovereignty. Low-income countries' visions of access to medicines and equity conflicted with high-income countries' desires to be protectionist around their industry, to not disrupt the traditional intellectual property system, not disrupt the traditional R&D model and system, and not place too many obligations on their pharmaceutical industry. So right from the very start, there was a lack of clear vision of what this treaty was wanted to achieve, and there were huge gulfs in inequalities in how they wanted what they wanted out of this. And as a result, there were unclear landing zones right from the very start of, you want this, I want this, let's trade. They were very, very unclear of what's the middle ground between these two positions, right? These positions seemed quite fundamental right from the very, very start. And in particular, there was this use of language of equity, which was pushed in particular by a group called the Group for Equity, which is a grouping of low and middle income countries who desired this vision that they had called equity. They wanted to improve equity. Problem was, no one really knew what they meant when they talked about equity, and there were very distinctive, different visions of what equity meant to different governments. So even the sort of conceptual foundations here were uncertain and unclear and poorly defined. And as we saw successive drafts move forward, we saw multiple definitions of what equity meant to governments. And one of the problems with equity is it sounds great. How could you possibly disagree with equity? But fundamentally, equity meant fundamentally different things to different governments at all time. So when governments were standing up, articulating and arguing in favor of equity, they meant something very different to the following member state who'd argue the same thing. So I would argue that one of the first things that member states have to do when negotiating this new treaties on disasters is have a very clear vision of what they are trying to achieve and a very clear idea of where we can go with this. have clear concepts, clear terms, ensure that everyone is essentially speaking the same language when they're making these arguments. Because whilst we were using the same terms like equity, we were speaking totally different languages and talking at cross purposes for lots of these negotiations. And in terms of the process, the way in which the process was managed made it much more difficult to reach consensus at WHO. So in the first instance, there was active desires to exclude civil society actors from the negotiation room. What this meant was that there was a lack of knowledge and understanding and advocacy coming from outside of member states. Member states insulated themselves from these external voices from civil society, which made it much harder for civil society actors' voices to be raised within these negotiations. And that meant that we then ended up with situations where we didn't get the expertise and the input from other stakeholders that we really needed to try and address this treaty. There were active desires as well to try and exclude other actors from the international legal system from these negotiations as well. In particular, organizations like FAO and the CBD, both of which have issues around this negotiation. The FAO was particularly concerned with how One Health was being operationalized in a treaty at the World Health Organization. The CBD was particularly interested in how access and benefit sharing was to be operationalized within this treaty, both of which found it very, very hard to speak as a stakeholder and influence these negotiations, and speak on the floor. Now, hopefully, having a treaty housed at the General Assembly of the World Health Organization will mitigate some of those problems. One of the things which we saw was the mandate of the World Health Organization being operationalized in a very particular way. So in some instances, the mandate of the World Health Organization was used to try and exclude issues from the conversation that member states didn't want being brought up. So issues like intellectual property. A very easy defense for countries who were trying to be protectionist of their industry was, sorry, this is the World Health Organization. We have no mandate to talk about IP here. If you want to talk about IP, go to the World Trade Organization, go to WIPO, and we can have a discussion there. But we can't talk about it here. Despite the fact that IP was this fundamental issue in access to medicine, we couldn't meaningfully address it because of this limited enclosed mandate. And that also became a problem with interactions with other members of the international legal community. Hopefully, having something housed at the General Assembly with a much more expansive, broader mandate can be beneficial here. The mandate of the World Health Organization, which likes to present itself as a technical agency, purely technocratic, scientific healthcare medical agency, also pose problems for us because health is fundamentally political. How we respond to pandemics is political. How we structure and order the societies is fundamentally a political choice. But WHO has this desire to ignore the politics and has done for decades, doesn't want to become political, doesn't want to get involved in politics, wants to talk about health systems, wants to talk about healthcare in a apolitical way. But that's not problem. That's not possible. So one of the other learnings I think that the General Assembly, that the disaster laws could take is embrace the politics, have them front and center of our discussions, because politics was everywhere in the negotiations of the pandemic treaty, but no one was willing to confront it, and no one was willing to speak openly and clearly and meaningfully about it. In terms of the process, the other thing which was particularly difficult was that the process was managed particularly poorly by the Bureau, which led to frustrations and conflicts with member states themselves. Text was produced late by the Bureau and didn't provide enough time for member states to seek advice on the next draft before the negotiations started. Sometimes member states first saw the text when it was put on the screen in the negotiation room in the round of the negotiations, which didn't give them enough time to negotiate. This was particularly detrimental to low-income countries with very small delegations in Geneva, who didn't have the relevant sort of large delegations with sufficient expertise on it in order to respond quickly. This created an environment where high-income countries could become more dominant of the discussion because they had relevant expertise and enough expertise in the room to manage these processes. There were also incredibly unrealistic expectations placed on the negotiations. I thought it was really interesting that in the introduction, Anthony talked about the fact that there's a deadline for this negotiation. And there was a very ambitious deadline put in place for negotiating the pandemic treaty of just 3 years, a deadline which they missed, by the way. And I would be mindful that member states should be very realistic about what they can meaningfully achieve in set periods of time, because those unrealistic expectations around deadlines made the negotiations much, much worse and made countries much more willing to compromise on things they really didn't want to compromise on just in order to get a deal over in time for the deadline. And this has actually led to a situation where we have a text, as I'll conclude it, we have a text, but it's nowhere near the text that anyone wanted, and it's quite watered down. And part of that is because of the process and how that process was managed. The process was also changed a couple of times during the rounds of negotiation, which led to inconsistent processes, which further created divisions between the Bureau and member states who were doing the negotiations. The final thing will be that I think disaster law can learn about from the negotiation of the pandemic treaty is around the geopolitical situation, which is fractured and fragmented and extraordinarily difficult. So as I set out at the beginning, we saw huge divides between high income and low income countries, divisions which still exist today and which are not getting better actually when we look at how negotiations are going. So we ended up with very, very clear divisions right from the very start, which made negotiations so much more difficult. We also saw influence of the Trump administration hugely. So first of all, being hugely disruptive of the process, withdrawing from the World Health Organization, but now actively undermining those negotiations through engaging in bilateral direct negotiations, in particular with African countries, around memorandums of understanding about sharing of health data, and that has now significantly affected the final stages of negotiations, which the pandemic treaty are in. So being mindful of the geopolitical situation and addressing those head on, I think is something else that needs to be understood by member states. So where are we? So we're in a rather odd situation right now because we have a text of as I said, member states set out with this very ambitious, we want an agreement by May 2024. They missed that deadline and gave themselves an additional year extension, in which time they managed to agree to almost all of the text. So they've adopted the treaty pending an annex. But the treaty cannot be opened for signatory and ratification until this annex is agreed on. This annex is the PABS annex, which is the pathogen access and benefit sharing part of the agreement, which is the part of the agreement that unfortunately Dr. Switzer and I work on mainly. So we're still sort of going with this. And it's also the area that's become most contentious and most difficult. There are 12 negotiation days left for the PABS annex based on the deadline which member states have set themselves. I don't think anyone thinks realistically they are going to make that deadline, and therefore another extension is going to be required. But nothing can happen until this PABS annex is agreed to, as things presently stand. So it's holding the rest of the agreement hostage. And unfortunately, none of those landing zones, which I talked about in the beginning, none of those clear visions have actually become apparent in the sort of 5 years which we've been negotiating PABS. There's been very little movement from member states. High-income countries think they've gone as far as they can. Low-income countries are unwilling to go any further until they see some compromise from high-income governments. So we're essentially at a bit of a stalemate. And that stalemate is in no small part because we still don't agree what we are trying to achieve with PABS. We still don't have a clear vision of what our landing zone is and what we want this system to do. We set out from the very beginning with this desire of, we want a treaty because treaties are good. They are powerful, they matter, they make a difference, without having any idea of what we wanted in it. And we want a PABS system because PABS will fix inequality, without really considering how PABS is going to function. So to summarize, global health law is experimenting with treaty law in the areas of pandemic preparedness and response, but the huge gulfs in what we are setting out to do and what we want to do, and the poorly managed process has given rise to significant difficulties, which has made consensus more difficult to achieve in the first instance. But that which we have agreed upon is actually not going much further than what was already there in the international health regulations, which failed in 2000 in COVID-19. We have a treaty, but we haven't made the world any safer, which I think is a waste of a treaty, quite frankly. And I think that I would advise countries who are, trying to negotiate a treaty on disaster law is take your time and do something meaningful rather than try to hit artificial deadlines and get something done. Because one of the things that sort of keeps myself and Steph awake at night is the idea that people think the world is going to be safer because we've got a treaty. But if that treaty doesn't work, and if it doesn't actually address the things that it needs to address, then it's a pointless bit of paper. And more than that, it creates an artificial safety net. It creates a false sense of security that we have improved the current situation when we have done no such thing as yet. And I would hope that in disaster laws that we can learn from what's gone wrong with the treaty and create something meaningful that's going to make the world safer. Thank you.
Thank you very much, Mark, for all those very practical insights as well, and not forgetting the politics, as you say, always with us. I've put a link in the chat to an earlier event at BIICL and report that Mark and Steph Switzer were instrumental in developing about the pandemic agreement, and in particular this issue of how we define equity and how it might be integrated and operationalized in a treaty. Also, this thorny issue, of course, of access and benefit sharing. So you can find further details of that on the BIICL website. I should also say, do please, our audience, do please type your questions in the Q&A box as we go along, so we can identify them during the discussion. So I'll hand over now to our next speaker, Giulio Bartolini. Thank you very much.
Thank you, Anthony, and also thanks a lot both to Therese for the invitation as well as to Mark for this very insightful overview of these other critical tests. I'm very glad to be here back with BIICL, also just because I was in the past year, some time ago, a visiting scholar at BIICL for some months, so it's my great pleasure to be back, and also sometimes I also had the occasion to continue cooperation with colleagues like Gochi or Christine there. So very glad to be here today. So, well, indeed, I really share lots of the concern that also Mark was mentioning, and also the process of the adoption of the text has some similarities with what's going with the pandemic treaty, with the difference that the pandemic treaty, at least except for the annex, is already there, while the treaty on disaster is really still on the way, and I perceive quite potential troubles for the text itself. But as people are usually not very familiar with the ongoing negotiation with the treaty on disaster, and also some of the technicalities and procedural aspects that Mark was mentioning have resonated in the discussion at the UN. Maybe it's helpful to go back a bit on the procedural history of the text, and then to address some of the elements that Mark was mentioning. In particular, the point I would like to address is whether the risk is to have an artificial legal text, so a treaty on disaster, which does not cope with the main issues that practitioners and experts perceive to be present. As well as another point I would like to discuss will be also the epistemic committee. So who is going to negotiate for this treaty, and what are the differences between the pandemic treaty or the amendments to the international health regulation? So let's go back, let me say, a decade ago, once the International Commission adopted finally the draft articles on protection of persons in the event of disaster. That's a quite thin text. It's made just by 18 articles. That's a point I will back on that. But at the time, there was quite a positive mood within the Commission that the text was covering a significant legal gap in the international community, while Mark was mentioning how within the area of global health law, they have treaties or other instruments since more than 100 years. In this case, on the contrary, the last Universal Convention dealing with disaster go back to 1 century ago, but there was one shot, and then the treaty, which was the Treaty for the International Relief Union, adopted in 1927, disappeared and was not relevant neither at the time nor as a sort of step or element through which build up a coherent universal system. On the contrary, we know how we don't have a universal convention on disaster, so there was a mood that there should be the need to cover this legal gap through a treaty in this area. And indeed, the International Commission, quite unusual, recommended to the UN General Assembly to adopt a treaty based on its draft article. So it was quite innovative at the time. Still, states were quite reluctant to engage with the recommendation to adopt the treaty made by the International Law Commission. The UN General Assembly adopted a sort of look-and-see approach. It asked states a couple of times to submit their views about the concrete recommendation made by the International Commission to adopt a treaty. States provided comments in 2018 and 2020, but if you count the number of states providing comments, it was a very poor number. So each time, only 6 states made some comments, very short, sometimes quite uncertain about whether it would be good or not to go for a treaty. So honestly, early 2020, I would say there was no chance, or there was no chance to have a treaty, except, and here there is the first interaction with COVID. I would say that, of course, the COVID-19 pandemic had also a pushing effect in the area of disaster law itself, as after COVID-19, as Mark said, there was a quite interest to shake the legal frameworks, and so at the global health law community, they went both for the reform of the international regulation as well as for the pandemic agreement, while states has also in front of them the draft articles of protection of persons developed of disaster. They say, okay, let's try to work a bit around it. And indeed, in 2021, the UN General Assembly adopted a resolution whose scope was mainly to force states to discuss the potential treaty, as they set up 2 rounds of consultation within the 6th committee at the UN General Assembly for 4 days each year, 2023, 2024, with the idea to discuss concretely in a very, let me say, detailed manner, what is the opinion of states about the content and whether the outcome should be a treaty or not. This round of consultation provide very helpful. They were also supported by some mentoring activities, like a bit of support provided by the disaster law program of the International Federation of the Red Cross, some meeting of experts aiming to, let me say, familiarize a delegation about the text itself made by academic experts and practitioners, which apparently proved quite successful, as at the end of 2024, the UN General Assembly finally decided to convene a diplomatic conference in this regard. At that point, let me say, things started to move fast, even too fast from my perspective, because basically the UN General Assembly decided states should submit by the end of last year, December 2025, potential amendments. So the idea was that in order to speed up the process, states should already put on the table their potential amendments to the treaty itself. And of course, this requires states to have a short reflection on the text itself. We don't know yet how many states have produced amendment. I know there are someone which were on the ready to submit. There were a lot of others which were far from being ready to submit. So I'm quite curious to read the report that the IHC, the Secretariat of the UN of the law, the codification division should produce in the next weeks to map how many states and not which idea they are going to put there. As already say to you, the text is quite short. I will be back on that. But just to conclude with the procedural elements, and also to go back with one point raised by Mark was, okay, they are going to have a diplomatic conference, which is going to take place in Manila 2027, and the deadline of the resolution is 2027, full stop. So basically, while Mark was complaining that states for the pandemic treaty had 3 years of concrete consultation negotiation, basically, there will be just one shot way in Manila, provided a pre-conf, which is going to take place for a few days, August this year. So basically, there will be a sort of pre-conf under the auspices of the CIS committee. There will be also a working group, again, session this year where states can continue to present their own views. So basically, the idea is if you were late with amendments in December, be ready at least in April this year to provide some concrete material, which might eventually, because be included in the report, in the consolidated text that the Secretariat of the Legal Division of the UN is going to prepare. But honestly, you understand that we are already a bit late because states should have provided amendments by the end of last year. And so here nowadays is already the idea, well, if you are late, maybe there could be room, but nothing is granted because it also depends whether the UN will have the resources to arrange for a, let me say, consolidated text, which should be based on the second round of consultation going to take place April this year. So things are getting not very clear from a procedural perspective. But in any case, the idea would be to have in Manila a consolidated text, which is basically the text provided by the International Commission with amendments made by states, proposed by states. I doubt there will be already a sort of pre-consolidated text. I think, as far as understood from some chats, that the text which would be submitted to states would simply be the basic draft articles plus ideas coming from states, but without from the Bureau trying to already pre-arrange some solution. So the idea would be to give to states what they have produced, and then it's up to them to find a diplomatic negotiation in 3 weeks in Manila. So you might understand it could be a very short time frame. And indeed, the original resolution in 2024 didn't provide only for the diplomatic conference in Manila, but the new resolution, which was adopted in 2025, already understand that some problems might arise and give a potential extension of 2 further weeks, not in Manila, but in New York in August next year. So they already fixed a sort of exit strategy, which of course might be, if the conclusion of the test does not go very well, might also imply the need eventually to have a new UN General Assembly resolution in order to postpone the deadline in case 2027 would not be the year in which states might conclude a treaty in just basically 1 year of concrete negotiation. The procedural resolution, which was adopted in December 2025, so a few weeks ago, was also already shattered by diplomatic clashes among delegations. They just discussed about procedural aspects, including the role of civil society there. And there was already a big division because there were a group of states, mainly led by Russia, which basically did not want even any mention to civil society in the resolution. The point was that the original proposal made by the core group, by the facilitator, which include Italy and Jamaica that year, was basically to have a formula similar to the Crimes Against Humanity Convention. So basically the idea would be to open the participation not only to states or international organizations but also to NGOs accredited to ECOSOC, so a quite significant number, but not a very extensive number, and for other NGO who would like to take the floor or to participate, the idea was to let me say, make a decision by the pre-conf in this regard in August next year. There were proposals by Russia and China to squeeze this possibility, limit it only to ECOSOC accredited NGO, and there was also the idea by China to have a sort of veto power with regard to non-ECOSOC NGO. So basically, there was a push to limit the participation of civil society there. I must say so far that is more a theoretical problem. To be honest, in the past working group where I was part of them, I was very astonished. As you know, there were two different working groups, one for crimes against humanity and one for disaster. For crimes against humanity, if you want to have a seat, you need to go there hours in advance, let me say, because it was packed, everyone was there in the balcony, it was filled by NGO. If you were for the disaster treaty period, the room was empty. Apart from delegation, the room was empty. There was no civil society except from the FRC, full stop. So that's quite astonishing. And it's still, I would say, emphasize how there is a quite diverged perception on the relevance of this treaty within the international legal community and the humanitarian community. There is no perception a treaty on disaster is ongoing, I would say, from main stakeholders, even main stakeholders, humanitarian stakeholders. And that's a problem with regard to the last point I would like to address, which is basically what might be the content of the treaty and what could be learned from the even the global health law system. The main point, which is already astonishing, is the content. So if you read the pandemic agreement, nowadays is 35 pages single line. Of course, there are some pages devoted to assembly of the state parties, which are not yet in the text because they were not yet proposed by the International Law Commission. But even if you limit to the bulk, to the substantive provision of the pandemic, is still 19 pages. The draft articles on protection of persons in disaster, you can squeeze it in 4 pages. So you can understand it's a very thin text. It's a text which looks like more a declaration by the General Assembly than a real treaty which would like to solve the problem. So the main aspect of the treaty currently is more a framework convention, because basically that was the idea within the International Law Commission to fix the major problem, to give states a guidance, an idea. But then if you want to have a treaty which really might solve the problem, states must put lots of effort in providing concrete amendments in order to enlarge the scope of application, to provide much more detailed provision, which could include some elements coming from the concrete expertise of states, humanitarian organization, and solve also some incoherent which are present in the text. My main concern is that I'm not sure how much states are ready to already come to the negotiation table with clear proposal and also proposal which are shared among states. Mark was mentioning potential shift between global south and global north. Here I see less problematic issues with regard to political divide. But then, honestly, no one has still yet discussed about cooperation issues, financial support, stuff like that, which of course will be put on the table by some states, and other states will start to disagree. And this point was not yet in the text. So you can imagine that everything, the more contentious issues will jump on the table in the next month with very short time frame to discuss and to provide for a diplomatic consensus. This does not mean that the draft articles and the text will not be worthy to be adopted. I still have the idea that it would be a major missed opportunity whether the international law community, will not be able to adopt a treaty in this area. It's probably one of the few areas of international law, international cooperation, which we don't have a universal agreement. We have a universal agreement of everything. Why don't we have a universal agreement for cooperation in case of disaster? It's a real misunderstanding or that it is not relevant to have a treaty in this area. On the contrary, we need a treaty, and the draft articles already provide a very good compromise. It has tried in several provisions to have a sort of check and balance. So basically, there are several provisions in which it accommodates sovereignty. Sovereignty is very well preserved in the treaty, but still there are some room for a bit more cooperative approach, a bit more open mind approach already in the text. So there is the chance to infuse in the draft articles, in the current text, a series of concrete proposals to improve the text. Sometimes it's just a matter of move stuff from the commentary to the draft articles. As you know, the International Commission consider the text and the commentary having the same value, but then you need to have a treaty which is with more wording, and lots of the points are in the commentary. It would be easy to, let me say, upgrade them to the plain text. But that's something that states must do. There have been some mentoring activities. I was also part of them, also Therese. The FRC produced a set of recommendations for states based on some discussion we had among scholars. But then it's still uncertain to me how much states have been able to pick up ideas from expertise there. Honestly, when you participate in the working group, and I'm going to conclude, there were no experts from the capitals. So it was not like a pandemic agreement, huge delegation from the capital, experts from civil society protection, whatever, going there. They were only discussing stuff from people at the sixth committee. I'm not sure, as far as I know, a lot of them get clear instruction from the capitals during the discussion. I'm not sure there were a wide participation, even including discussion, participation at the national level with civil society, which might have provided some inputs to their own government. It was quite, let me say, neglected area of discussion. So the main point is that the discussion will still lead within the sixth committee, which is very legal point, without the required expertise from experts from the capitals, from disaster management authorities, and others. On the contrary, we know from the pandemic agreement, on the contrary, there the problem was that there were few lawyers around. Here it's full of lawyers, and you don't have practitioners. So I still see some challenges which should be, let me say, addressed. We still have some time, but we don't have a huge amount of time. Still, let me say, next month will be crucial in order to permit to align the system of mixing the expertise, providing more content to the text. There is still room for improvement. I don't see a reason why the international community should fail on that. The treaty is already a good starting point, but there is real a need to include in it much more elements, and indeed also the report, which was arranged by Therese and her colleague, is already a starting point for providing states with further food for thought on that. And I conclude on that.
Thank you so much, Giulio. That's really fascinating overview. I'm sure people are going to want to come back on the Q&A about these difficulties that might be faced in trying to flesh out this framework at a time that, does not seem so auspicious for multilateralism and seeking financial support between states. But I think we'll come back to that in the questions. So thank you very much. I'll hand over now to our last speaker, Therese O'Donnell, who's going to present this important policy brief. Thank you so much.
Many thanks, Anthony. Many thanks to both Mark and Giulio for their absolutely fantastic contributions on the panel this morning. As has been mentioned already, this is an ESRC funded project through the Impact Acceleration Scheme. And we were indebted to that support, which was also obviously the support of Strathclyde University and our law school in that particular endeavour. My colleague, Dr. Stephanie Switzer, I know is present with us, and she was my co-investigator on this project, and her contribution cannot be overstated. I'm also delighted that we have a small participant who was with us through the drafting of the project and who was maybe tucked away for a wee while, but he has now emerged, and so delighted to welcome Finn as well to the project. He was a crucial member of the team. Also, my colleague, Dr. Miroslav Sadowski, who was our knowledge exchange champion and who was absolutely invaluable on the project as well. In terms of our partners, of course, BIICL as ever faithful, ever supportive, and the hosts of this morning's webinar, and particularly thanks to Anthony and Liam this morning for their support throughout today's organisation and the organisation of the workshop, which I'll talk about in a minute. Thanks to, as Anthony has already mentioned, to the Commonwealth Development Office, the team there who participated in the workshop and gave invaluable feedback on our draftings. We couldn't have done it without all of you. So I think that's all my thank yous done. I hope there's nobody I've missed out, and I will move on. This project inevitably has had a longer genesis than appears. The policy brief, which we completed at the very end of 2025, represents the summary of a lot of work of about a couple of years standing. Both Steph and I would talk at our coffee breaks, not that there were many of them, at work, about each of our research areas, and we came to the conclusion that we overlapped so much and we had such common themes that we should explore that. And the more we explored, the more we found. And so we decided that it was auspicious timing that as one treaty was sort of coming to its conclusion, although not quite given PABs, but it was motoring through the process much quicker, and the disaster law treaty was on the rise, that this was an ideal time at which to address those overlaps and what lessons could be learned. And of course, we had a workshop in October 24. Things moved on with the pandemic treaty in May 25, and things moved on with the disaster treaty in terms of the prospects for its conclusion, which, as Julio said, looked pretty bleak at one point or non-existent, and then were given impetus and then given further impetus by the conclusion of the pandemic treaty. I think it would be fair to say, that a treaty in relatively related subject matter could happen. So I think that there was always one eye on the other's area, as those involved or lobbying for such instruments were in preparation. So what will the brief talk about? I'll give the summary of recommendations at the end, and all I can really do is talk about the purpose of the project that we engaged in and why we engaged in it, and what we discovered during the process of engaging in it, and what then ultimately leads to those recommendations that I will address at the end. Our view, as I've already said, was that international disaster law and global health law have a very similar scope, ethos, and contextual relevancy, and there are significant overlaps. Both tackle the occasions of crisis when health and well-being are seriously jeopardized. As I've said, both areas were at crucial stages in their legal reform or development. And interestingly, both actually expect and demand interdisciplinary approaches. We can see very obviously in the context of health issues and disasters that scientific input is crucial. During COVID, all we heard was that we should follow the science. However, I think has become much more clear in the literature over certainly the last 10 to 15 years is that social science has an enormous input in this area. That might be anthropology, it might be history, it might be geography, it might be sociology, it might be any number of these disciplines, but all are increasingly interested in the disasters field and the health field. What I would also say is that I think research is really vibrant in these other disciplines rather than law, apart from the small communities, as Mark is very prominent in, as he said, in the pathogens and in pandemic law. And as Julio has mentioned, the rather small community of disaster lawyers that exists compared to other areas of law. But what's interesting is critical history and critical geography has been extremely active in these fields. And so what are the insights we can learn from that? On that note, I think all of us engaged in the project were very keen to highlight the science-law-policy interface and tensions that exist when moments of crisis appear. Also, I think it's fair to say that both areas have increasingly rejected the snapshot approach for the cycle. We have already alluded to the issue of preparedness, response, and then the Build Back Better, or whatever it might be in different areas of law. But we are more attuned to the notion of different stages and being attuned to the interrelationship of those stages. Both global health law, as Mark has alluded to, and international disaster law pose significant questions regarding modern versus traditional understandings of sovereignty. And I think Giulio has already mentioned issues of sovereignty, and certainly the north-south, global north-south divide has been very keenly revisited in debates, I think would be the delicate way I could put it, at the Sixth Committee, for example. Both areas also raise very profound questions regarding the sharp end of realising what we mean by solidarity in international law. Solidarity is often proclaimed, but the reality of that, a bit like equity or equality, that's much more difficult. The nitty-gritty, the realisation, the operationalisation of these very, very high-minded principles is extraordinarily thorny, as I think was the turn of phrase that Mark used. Both global health law and international disaster law also engage questions regarding non-state actors. We know with industry, with NGOs, civil society has already been mentioned, the Red Cross. Both engage, both areas rely actually on many of these actors for the operationalisation of many of the laws. But at the same time, as we've already discussed, there are struggles regarding stakeholder engagement, particularly in negotiating processes. Furthermore, both areas have seen concerns regarding the securitisation and militarisation dimensions within their fields, and that has given pause for anxiety as to the drift of areas and the seepage between different legal regimes and norms and preconceptions that might arise. For example, international humanitarian laws, precepts being somewhat unconsciously or not reflectively mapped onto disaster law. And ultimately, all of that, both global health law and international disaster law, raise serious questions, regarding the international, domestic, regional interface of regulation and the kind of need for a joined up approach to that. As we've been hearing over and over this morning, global health law has been reformed very significantly recently with an international health regulation overhaul and the pandemic agreement, notwithstanding the sticking point on pathogens and benefits sharing. The IDL treaty, for those of us who've been involved in it, has been much anticipated in 2 decades of work, and undoubtedly, as Giulio said, was given added impetus by COVID and by the pandemic agreement. So that's been really interesting, that in a sense it's been sort of on the shelf for a while and has been brought off, dusted down, and moved forward with nothing happened. Then something is happening very quickly, and that's often how people say how they lose their money, and it's equally dangerous possibly here. In disasters, what we see are there are many actors and multiple levels of activity and a lot of bilateral cooperation, but generally speaking, it's been considered to still be relatively chaotic, with unnecessary delays then in the delivery of assistance to stricken states. We see overlaps in context and legal principle between the two areas. For example, what's the substance of a protective duty? Which actors bear the duties? How can frameworks, including legal frameworks, allow for the best coordination on the ground? And what do we have in terms of questions of planning? So our workshop, just to be clear, and our report focuses less on the how to make things better and more about lessons regarding the legal practice. So this is, again, going back to the title, we are interested in what lessons we can learn. And Mark's presentation this morning has been extremely instructive in that regard. What we would say is that in the context of polycrises, which are there's been an increase in polycrises. In the context of those, which are the interaction of disparate crises leading to excess harm, we can see the transformative potential for legal change. But states can differ in their receptiveness to change as regards disaster law. Some are very anxious regarding further legal fragmentation. Some are utterly opposed on sovereignty grounds. There are tensions regarding sovereignty, cooperation, which we see as a more reciprocally driven concept, and solidarity, which we see as more about the common interest. And what I guess we were concerned about was there are dangers of mere preambular declarations of solidarity rather than substantive provisions in that regard. We also saw that there are issues regarding transparency, inclusivity, and compliance. There are hard lessons from the pandemic agreement regarding that. And we also saw as important the integration of values into law. We saw issues regarding the insurance of equity. We saw issues regarding the legal coherence and fragmentation of laws I've already mentioned. So, for example, the role of human rights law, the role of international environmental law, the role of international humanitarian law, all of which have at points touched upon or bumped into disaster issues. We've already talked about non-state actors, the issue of codes of conduct, which have been very, very prevalent in disaster law, principally from the Red Cross and various other organisations. We've had concerns regarding NGO malpractice and the fact that NGOs are a heterogeneous community. We also wanted to learn from other contexts as to how you have follow-up or enforcement or monitoring of the provisions of any legal instrument, which ultimately is concluded. How can you make sure some of that is rule of law compliant? What about legal preparedness? What about the role of a conference of parties, for example? And I think Mark's comments on the kind of input of the COPs, or lack of input, or more modest input, has been quite instructive in that regard. So there are a number of issues which came up as very live ones in the context of the prospective disasters law treaty. The other point, another point that I would highlight is that we were, as I said, very keen to have an interdisciplinary, multidisciplinary perspective on this issue. And so in our workshop, we were keen to have a panel which addressed that specifically. And we therefore involved a panel which would consider science, data, law, and policy. And that was informed by much of the practice that had been seen pretty much ad hoc and sprung up from the ground in the light of, in the context of COVID. But was there anything to take from that? As I said, we're often exhorted to follow the science, but that can be very fraught. And in the middle of a crisis, it is probably not the right time to suddenly turn to the scientists as if they're going to produce some magic bullet to solve this problem. What was clear during COVID, and I would say during the pandemic agreement negotiations, was statistics were catapulted into the limelight, and we were keen to understand statistics, the idea of modelling to existing data being much more manageable and much more reliable, rather than modelling to prediction, which is very tricky, especially in a pressured environment. What became clear was that data planning and management has to be done early. And we wondered about legal obligations for states to bank and share data in advance. At the same time, of course, that raises human rights concerns, privacy safeguards, national security concerns. It also raises very fundamental questions which are probably beyond the discussion that I would be able to offer on what constitutes data, and that data is not neutral. And I think we can probably see a lot about that in recent debates about what constitutes data more broadly in political discourse. In terms of manufacturing and delivery of assistance, the goal of salvation isn't enough. You need good faith between states, and oftentimes that will need regulatory flexibility, which can make everybody a little bit queasy. But we've seen the dangers of supply chains and stockpiling. And I think the pandemic agreement flags concerns regarding funding streams for implementation. Where's this going to come from? This maps on to the question mark over the offering of assistance to stricken states in disaster law. It's all very well proclaiming it, but should there be some attention to, if not an existing duty or an existing obligation, but does there need to be something more to nudge states beyond their own choice, their own conscience, or their own good faith? That, I think, is something, when we look at the experience of the pandemic agreement, really strikes us. And I think we can see from the PABS wranglings, from the failure of the COVAX initiative, and the shortfall in flash funds that followed for disaster appeals that followed the onset of a disaster, the UN flash funds, which are often nowhere near close to meeting their target. I think this shows how commitments to solidarity and equity can be very fleeting indeed. And unless there is some form of legal instrument to at least proclaim it in hard terms, we might really not be any further forward with our endeavour than we were before we even started drafting material. What I would say to you is that we had particular regard to the Scottish Government's four harms approach, which was adopted as a way of understanding, of being transparent and checking decision making in the Scottish Government during COVID. It was a multidisciplinary collaboration between social scientists and policymakers that created a framework to guide the Scottish Government decision making. And it looked to tackle, for example, the direct and indirect harms of COVID, but also to look at the harms occasioned by the legal measures which have been taken to try and tackle the difficulties of COVID, and to think about counteractive measures as quickly as possible. This was we found in our discussions, and our report pays attention to this, a dynamic and agile mechanism that was employed in Scotland. Of course, we're going to be committed to that, but it did seem to be very helpful. And it saw things like academic partnerships being very relevant. It also highlighted the importance of clear communication and transparency of methodologies. It also even looked to the future, and it used things like gaming scenarios or simulation models. It also endured beyond the pandemic and created relationships for the future should a disaster happen. What that highlighted was the value of structure and language for difficult conversations, but it also meant there was one collectively responsible voice for policy making. That's something that I would think is actually worth bearing in mind. I think that I'm sure the global health lawyers wouldn't disagree with me on that. And I'm wondering if there is some notion that could be built in to the planning or risk obligations that are within the treaty, that there should be some mechanism for monitoring, follow-up, in a sense, almost the human rights law model of report cards as to how states are doing in their endeavours. What we would say is also that One Health, which has already been mentioned in the context of the pandemic agreement, was obviously an extremely important ethos, I think, that guided the provisions there. This mapped somewhat onto the Sendai framework for disaster risk reduction, which is peculiar to more the disaster field. But both areas of law and both of these instruments are focused on stopping a hazard becoming an emergency. And both of those instruments address risk specifically. So there, I think we can see, without going into the nitty-gritty of what those approaches are looking at, we're looking at how do you monitor how states reduce risk? Monitor, I mean, Mark's spoken again at the beginning about the sense that some states were sleeping on the job when it came to monitoring the presence of disease in their territory. But what's interesting is One Health is an approach, whereas Sendai is a framework. So in a sense, I don't know if that makes one more useful than the other. One maybe speaks to law more in terms of its approach, but the other might govern a mindset, which might actually be more useful than a more obvious textual contribution. What we also have to be mindful of is follow the science, follow the knowledge. Where's the knowledge basis for your approach? But what constitutes knowledge? And I would urge, I think I would speak for the team, the drafting team here, we are very concerned about what constitutes knowledge, because while Indigenous knowledge is acknowledged, sorry, that's a lot of the same word, in Sendai, it is hardly preeminent. And so I think that if the treaty could pay more mind to that, and I think also that that was an issue, when you map it with civil society involvement, you map it with who's going to be managing this on the ground. That is really quite an important dimension. And at the end of the day, both Sendai and One Health talk about an all-of-society approach and all-of-society engagement. So in terms of going forward, so I will finish, Anthony, I'm conscious I've gone quite far time-wise. We have a number of concluding thoughts, and these effectively formed our key findings and recommendations. First of all, the issue of transparency and inclusion. We're always talking about how we make international law more complied with. You make it more complied with if it's perceived to be more legitimate. You make it more legitimate if you're more inclusive. It's not really hard to figure out. So what we would say is we have to ensure, the treaty negotiators have to ensure inclusive stakeholder engagement in any international disasters treaty. We need representation from not just civil society, but local communities and stricken populations. And we have to prioritise transparency in decision-making processes, accompanied by processes for monitoring and review. The pandemic experience has been instructive in that regard. We also have to integrate equity, solidarity, and human rights. Human rights is mentioned in the Disasters Treaty, as is solidarity, but it needs to be, these notions of equity and so on need to be embedded as underlying principles at all stages in disaster governance. We think that codifying a duty to offer assistance would give a hard edge to that notion of solidarity. And we also think that the human rights protections currently mentioned, and that's good, but perhaps need to be embedded a little further into the treaty. Post-disaster reflection and investigation has to be included, and that would allow us to fulfill human rights obligations. And I think that therefore, and I think this has been discussed really extensively in disaster law circles, is what are we going to do afterwards? So the conference of parties or whichever model of monitoring and review is really crucial here and can't be left because it's currently not really appearing in any meaningful sense in the draft. We also want to suggest that multilateralism and regional cooperation is promoted. There is quite a lot of regional cooperation, but that needs to be capitalised on and not sit aside from any disaster law treaty as it might be concluded. As I've stressed over and over, we want to promote science and policy interaction and iterative responses, and so perhaps we need to establish processes for that. Treaties, as Mark has said, are not super trendy, if you like, as a lawmaking mechanism, perhaps because they're not living. It's not a static instrument. It has to be a live, agile, evolving, relevant instrument, perhaps more along the lines of international environmental law, as we've seen there. We need intersectoral, multidisciplinary approaches to be built. We need to think about how we communicate in the context of disaster law. We need to consider the private sector and be clear about duties of private actors rather than retreating to due diligence of states in this regard. And as I've said before, thinking about risk and thinking about the four harms approach, which we deal with quite a lot in our report, we think would be very helpful. It was a really enriching project to be involved in. I hope the policy brief will be useful. It took us a lot of time and reflection to think about what we're going to do here. And we'd like to think that how we involved partners and how we took our time and how we gave a lot of attention to it might show just what, in a very small way, is actually needed here. And I think maybe if there's any scope to give ourselves a little more pause to get it right, because it's probably our one opportunity to do so. And I suspect that the more that disasters begin to affect the global north, perhaps the more we will see an interest in this area. And it can come to us all, as COVID showed. That was a big instructive lesson. But the loss was not equal. And I guess that's not right. So I think we have to bear all of that in mind going forward. And we hope that the policy brief will provide food for thought for negotiators to the Disaster Law Treaty. Thank you.
Brilliant. Thank you so much, Therese. That's great. And just to remind everybody, of course, do please go and access that report. It's up on the event webpage on the BIICL website. You can read those key takeaways in text form. And a question that I think is very relevant to what you were just saying, Therese, actually about that we've had from the audience, from Nicola Yoxall. When you were talking about the value of like legal frameworks, more legal frameworks versus approaches, versus an approach that's all about shaping a mindset. But Nicola's asked, if the opinion is that multilateral treaties are dying as a way of helping to solve global issues, and then she also says, or if they don't carry the same political weight that they used to, maybe people aren't as compliant as perhaps they might have been in previous years. Then she asks, well, what would the next best alternative be as legal strategies other than treaty?
Do you want me to take that? I suppose I think we probably all have something to say.
Yes,
about
I think
that.
all of you can.
I mean, I think it's really interesting to look at where treaties are happening. So, I mean, no one's going to have human rights without a treaty, right? So it's quite interesting that, and when you look at instruments and the fashion for instruments, if you like, so you look in 2006 and you have the Yogyakarta principles, which have been a big success in terms of LGBTQ plus rights, and that's done because it's a treaty. It's not a treaty or something else. It's not this instrument or something else. It's this instrument or nothing, right? But the same year, the Convention on the Rights of Persons Living with Disabilities gets passed. So we can see that in the human rights field, there's a kind of, it depends, it's horses for courses, it depends what states will commit to. So I think we've tried in disaster law, we've tried loads of instruments, and Julia will speak to that a lot more than I will. We've got a very, very diverse toolbox. And so the treaty is the one thing we haven't had, and that's what's being supplemented. So we still have all those other tools. And they've done really the best job they could do, like the Red Cross, the Sphere Handbook, the Mohonk criteria, the IDRL rules of 2007 in particular, which actually formed the basis of much of the treaty, ethos texting, draft in detail. So we've done all of that. And, we're still getting people in a mess, basically, in disaster situations. So I think that if we can speak to that trajectory, we can sort of justify why we might need a treaty, but not just any treaty. I guess that's always the thing. And I think Mark will probably be sympathetic to that. And I guess what else? Well, we would go back to where we were. And if people are comfortable with that, then that's fine. States just have to, take cognizance of that. Of course, we can have customary law. We can start talking about customary obligations, and then there'll be no choice in it. So I don't know what the next best thing is. I think, well, we've got a lot of the next best thing already in disaster law, but I'll leave it to Julio and Mark to. I don't know if that addressed the question, but it was, I guess, comment to the question.
No, and I completely agree with what you've said there, Therese. The one thing I'd add is that the last bit of Nicola's question, which I saw come in, was wins for multilateralism in the current global climate. How much importance do you attach to these wins? To which I'd say is, well, what do you count as a win, right? Like merely getting an agreement, irrespective of the substantive content, is that a win for multilateralism? Merely by the fact that we've managed to reach consensus on anything and we can wave a piece of paper in the air and say, look what we managed to achieve. Is that what we're counting as a win? I personally no, right? And this is some of the rhetoric which we've had around the pandemic agreement, and I'm very much of the mind that no treaty is better than a bad treaty. Sorry to sort of reference back to some of the arguments which we heard around Brexit in the UK. But I genuinely believe that having no treaty is better than a bad treaty, because as Therese was referring to, right, like once we get the treaty, that signals a degree of finality within global health law, right? We're not going to reopen this in 2 years when we look through or 5 years when we look through the text and go, oh, actually, this isn't that great. We need to change it, right? That is our decision. We have fixed that. We have set that in stone, and we would only come to change it once we've realized it's not working. But once we've realized it's not working, it's too late, right? Like the harm has already been caused. And the thing that worries me, particularly with the pandemic agreement, is the false promise, right? That we move on from talking about pandemics and inequality and access to medicine because we have the treaty. We have this solution now, right? It's presented as we diagnose the problems, we've got a solution, and we will next revisit that question in however many years it is until the next pandemic. How long that is not that long, unfortunately. So I think it really fundamentally comes down to what you think a win is. And I don't view mere agreement as a win. I think genuine substance that makes genuine meaning, the kind of genuine meaningful change that we require within each one of these fields, is what counts as a win. Now, that doesn't have to come through treaty, right? And actually, lots of the progress which we've done in areas around global health have had nothing to do with treaty law whatsoever. What they build on is political capital, sustainable financing, and a common agreement of what we're trying to do and what we're trying to achieve. You don't need a treaty to do that. Sometimes a treaty is the resulting effect of all of those things, right? But you can't generate political will via a treaty. You need political will to get a treaty. So I do worry that we're sort of doing things in the wrong order in particular, right? And it's that thing of once you've got a treaty, you no longer need it, right? Because you're in a position where everyone agrees on these fundamental principles, these ideas, these binding commitments. So I would question what we count as a win, and just getting an agreement within an ambitious timeline that we set just to say we hit a goal, I warn very heavily against doing. But over to Julio.
Yeah, I can just echo what Therese and you said. So I still, of course, we start from the assumption that the treaties could be a good starting point for fixing some issues which require international regulation. This might also be the case for disaster. Again, my main concern currently is the content of the treaty which will be there, and also whether the text which will be agreed will get the support by relevant stakeholders, which of course include in particular the states, both the states who are more which are prone to disaster, as well as the ones who are a bit more prone for providing assistance. So I still have to understand how much there should be combination between the two, between these groups of states. Then again, can we survive without the treaty, universal treaty on disaster? Well, we have survived so far. So of course, it would not. If there is not, we can continue to try states to cooperate, humanitarian acts to cooperate, and so on and so on. But at the same time, probably it would be relevant to have a text on this topic, as it might facilitate also in the subsequent steps through also the activities of the conference of the parties, a continuous engagement on that, continuing to maintain it as one of the potential priority in political and humanitarian agenda. So the text itself might also have a sort of follow-up effects, but still it depends on the number of states which would be behind it. We saw recently in terms of multilateral, in a bit more technical area like the BBNJ, it has reached a quite significant amount of consensus. Also, the ratification process was very, very speedy. It entered into force in less than 2 years, which signal, of course, that the text finally, after lengthy negotiation, had a lot of meaning for concerned states. Here we just hope that that would be the case. But again, I'm a bit generally worried about lack of rumor about the Treaty on Disaster, which means that I don't see a lot of engagement by states, a lot of engagement by civil society, by humanitarian actors. It's still below the radar, even if it will be tomorrow, basically.
Great, thanks, Giulio. Thank you all. A follow-up question that's posed to Giulio. It's from Kees van Happeren, and he's asking, rather than, I can see in all of our comments, a common theme, I must say, is a lot of worry about the international order and multilateralism, and is it a time of crisis for international law? But Kees van Happeren is asking, rather than focusing on a universal treaty at the UN, should you perhaps instead be focusing on the regional level, agreements of regional blocs on the issue, and perhaps expanding on regional agreements that already exist?
Yeah, that would be an option too. So basically, well, there is already a net of regional agreement, but then regional agreement have a series of limits. Just to give you with a concrete example, also in terms of treaties which do not fly. In the Organization of American States, which of course is a very broad organization in terms of membership and geographical representation, they already have a regional treaty which goes back to 1991. But it has just 6 state parties out of more than 25, 28 states members of the Organization of American States. So after 3 decades it is in place, or even more, the treaty has not reached any consensus, and of course it means that it is not a meaningful text, even if it is written, maybe it's even published in the UN Treaty Series, if they have registered it there. And so that's one risk for a regional agreement. There are areas where there is no regional agreement. Africa, it does not have a regional agreement. Asia, Central Asia, it does not have a regional agreement. With Europe, we are a bit used about the European Civil Protection Mechanism, which of course is not per se an agreement. It's based on secondary law by the European Union. It works properly, but it's Europe. And then what happens if you would like to provide assistance in the region where a regional agreement exists? The regional agreement, the text of the current one, mainly provided for facilitation, or they are built up on intra-regional cooperation. So states in the Caribbean going to provide assistance to states in the Caribbean. But what about if states coming from abroad would like to provide support? What about NGO, which might be linked to some states which would like to provide support? What about regional organization? The European Union going to provide support in the Caribbean? What would be its legal status? So there are a series of shortcomings on that. First, that we need to start from scratch to negotiate regional agreement in multiple regional organizations, sub-regional organizations where there is none. So basically the only relevant regional framework, one of them is the European Union one. In the Caribbean, it works quite well, but except from these two exceptions, multiple other regions will be outside. So I would still prefer to have a universal text, which of course should accommodate the concern of states from different regions, which of course might also facilitate a bit broader international cooperation in this area. But of course, the idea, and indeed there is a specific provision in the draft articles 18.1, will not be to dispel and to replace the role of regional agreement. On the contrary, the draft articles, the text says that, well, if, for instance, other texts, including regional agreement, have something to say more in terms of the content, in terms of specific provision which will be more detailed, they will take precedence over the new universal treaty. So basically, there is also the idea of with sort of complementarity, in which first, if regional texts are fit for purposes, they will go. Also, whether, let me say, for some elements, the pandemic agreement will say more than the universal treaty, for sure it will take precedence. So the universal treaty will act as sort of legal safe net, lacking more specific instruments. But as said, in multiple cases, there are no more specific instruments.
And just to give the example from the global health environment, which has a very regionalized structure, and that's a sort of historical thing from the existence of PAHO, the Pan American Health Organization. But so WHO has a regional structure. There are each one of the regions. Each one has a regional director, which has some degree of autonomy. But what this has led to is number one, a battle between headquarters in Geneva and the regions about just how autonomous each one of the regions are, and funding of those regions in particular, and how much work they have. But the other thing we've seen around regionalism is efforts being made by regions completely departed from the multilateral system, away from WHO, doing regional initiatives. We've seen this in Southeast Asia in particular, but also growing within the European Union. PAHO has always done its own thing to some degree, but we've also seen, and Mercosur in South America, but we're also seeing, particularly during COVID, we saw growing African regionalism. So we saw we've got the African Union became heavily involved in pandemic response across the region, largely to make up for deficits from the multilateral system. So we had joint African procurement around vaccines of African countries collaborating with each other to try to formally procure vaccines on a group basis of putting in a larger order, try and work with economies of scale. To try and procure on behalf of multiple countries. We've also got the African CDC, which has recently launched, based in Addis in Ethiopia. So there are activities happening within regions, and in particular growing initiatives around Africa, as well as sort of growing desires to have regional manufacturing capacity on the African continent. One of the big challenges for this is the sustainability of the financing associated with them, not just in Africa, but it's more of a pronounced problem on the African continent, but within lots of countries, within lots of the regions. Because Europe aside, which, I mean, it's still a problem within Europe, but one of the things that we see with the regions is huge degrees of inequality between members of those regional blocs, right? You have very wealthy countries and very poor countries grouped within the same region. You see that in the Americas, you see it in Southeast Asia, you see it even in the European bloc and the African bloc as well. Very different countries with very different levels of development, having very different desires and wishes. So the sustainability of the financing associated with those becomes particularly challenging, right? And sort of theoretically, there is this desire or there's this vision of going, African countries have more in common with other African countries. They group together, they work together. Europe isn't giving them what they need. North America, the Western countries aren't giving them what they need. There is this Pan-African solidarity where they can group together, which to some degree is a vision that can work, right? But actually, when you dig into that, actually, there's a very, very big difference in terms of economic development, in terms of manufacturing capacity, in terms of wealth inequality within African countries as well. So these sort of problems that we see on the multilateral scale are also presenting themselves at the regional scale in terms of huge inequalities between countries within regions, an unwillingness of countries to basically sustain the financing on behalf of all of their region. So how far those regional initiatives can go, I think, is sort of fundamentally remains to be seen. But it is probably something that we're going to see happen more and more regional initiatives. They might be sort of quite small scale at first in terms of collaborating together on joint procurement of resources, joint manufacturing capacity, a joint center of disease control that we're seeing in Africa. But there's a growing initiative there. The scalability of it is the challenge, particularly around sustainability of financing and the extent to which countries who happen to exist within the same region face the same challenges, the same difficulties, and want the same outcomes. And as you know, some African economies grow extraordinarily quickly, which is what we're seeing on the continent, the divide between those very wealthy African countries and those underdeveloped African countries or less developed African countries is probably going to grow and make true sort of Pan-Africanism responses much more difficult.
Great, thanks, Mark. Someone has gone, I don't know if anybody's going to want to tackle this one. Dr. Kishore Shankar Dere, on a similar point, he's gone and thrown in the T word. The Donald Trump is here. Is asking, I think, and maybe Mark wants to address this one because I know you mentioned Trump earlier and difficulties with the pandemic agreement. He's asking if these issues desperately need international trust and cooperation, global solutions, what is the consequence of the Trump administration and withdrawal of the USA and disengagement?
So you're completely right. Trust is the fundamental problem here. But one thing I will say is trust was at an all-time low long before Trump got into the White House, and trust will be at an all-time low before, once Trump has already gone. Sure, he's trying to set fire to everything on the way out, but fundamentally, the sparks were already there. The huge inequalities which we saw during COVID really eroded trust between high-income countries and low-income countries. That was under the Biden administration, when we saw huge amounts of vaccine nationalism, when we saw border closures, when we saw hugely discriminatory border closures being imposed by high-income countries on sub-Saharan African countries in particular after Omicron. And let's not be under any illusion, right? Biden wouldn't have signed the pandemic agreement. Obama wouldn't have signed and ratified the pandemic agreement. America has always had an American exceptionalist approach to international law. They do not sign treaties. It's very hard to ratify and bring them into effect in the US. The famous example is the United States hasn't ratified the UN Convention on the Rights of the Child, one of only 2 countries in the world to have not done so. So let's not pretend that this is a problem exclusively of Trump. Trump is actively making things worse, right? But the behavior of high-income countries across the spectrum of North America, Europe, Japan, Australia, and so on, in terms of vaccine nationalism, led to huge erosions of trust. And this made it, the negotiations really fractious. They became really challenging and difficult and quite personal at times. You had delegations standing up talking about their family members who died because you and your government did this to us, which made negotiations really difficult and really fractured. In some ways, the issue isn't Trump. The issue is what happens after Trump. Because I think lots of us would like to exist under the illusion that once Trump goes away, all of life returns to normal. the US gets to go back to pretending it's a sort of, liberal democracy, leader of the free world kind of rhetoric. But that is just not the case, right? And what comes next and how long it's going to take for the US to rebuild its trust within the international community and rebuild its sort of hegemonic position is going to take a very long time. But also, I think that there is an opportunity there, right? The US as a hegemonic power is an undesirable thing. Hegemonic powers in general are undesirable things. There is an opportunity here for power to be more dispersed amongst the international community, for a global health system or even an international law system which is not as dominated by the US or any other hegemonic power as it has been since World War II, basically. Like, there is a chance here to build a better system. One of the problems that we're facing is that lots of countries just don't have the faith in multilateralism to rebuild a better system, right? It's not just a problem of Trump. We are seeing countries becoming far more insular, far more nationalistic across the geographical spectrum and across the political spectrum. We're seeing the rise of nationalism everywhere on pretty much every continent. And that's the really scary thing. Trump is a very good example of that because of how sort of hegemonic and dominant US news and US media is, particularly in the UK, but this is a problem everywhere, and this doesn't go away with Trump. And just going back to that question earlier from Nicola about wins for multilateralism, I think lots of people in global health were very excited that we had a win just by having an agreement in multilateralism, because it stuck two fingers up at the White House in many ways, right? We did this without you. We did this despite your best efforts. We have solidarity. You are the outlier here. You are in the wrong. But if that doesn't change lives, if that doesn't make a difference, how much of a win actually is it? And I think we're seeing waning faith in multilateralism across the board, and rising nationalism everywhere. And that's the bigger worry, I think. But that's probably a bit of a depressing point to make. So, Julio, Therese, do you have something a bit more positive to add?
I do and I don't. I mean, I was struck by your comments on the pandemic agreement and these wee bilateral side dishes that the US is concluding. And we've been here before with the International Criminal Court statute, which obviously famously the US signed and then unsigned and then is not a party. And it's always cited as one of the states, along with the others that we know, that aren't parties. But the ICC still exists. The ICC still operates and it still prosecutes people, right? Okay, there's lots of issues about it, lots of controversies and debates, and we know them. But the court still happened. And it also becomes, okay, look at the company you keep, right? So I think obviously treaties operate in two milieu. I think there is you've just addressed that in your concluding point, which is they contain legal obligations of, say, cooperation and rendering to that court, but they also have a political value, right? They are a political player there. Your participation or not is a political scorecard, really, for want of something else. And so I think I was really struck that the exact same MO, as you were saying, this isn't really about this is about maybe the office of president or the state rather than who occupies that office, right? So that was George W. Bush did all of that, and Clinton was very resistant, not that keen on the International Criminal Court statute, but thought there's room for maneuver here. And so here we are again. And I thought it was very telling that when there was flooding in Texas, I think last summer, the state that actually came to assist was Mexico, right? And funnily enough, there didn't seem to be too much immigration back and forth about that. And they just walked across the river and assisted. And that was a situation where a state that should be able to look after its own people, given its resources, but it's got a really, really difficult structure of FEMA, needed international assistance, right? It actually needed international assistance. Now, what's the point? The point is that there was international assistance needed because it couldn't be delivered by one of the world's preeminent economies, right? That probably will almost certainly not be a party to many treaties over the next, coming years. But nevertheless, it didn't matter. It still happened. Now, you might say that means you don't need a treaty. Oh, no, you do, because there's no guarantee of that. And there's political repercussions for that. We see that in China, that actually there were disasters happened. And the response to it by the state was very much as it would have been in a democracy, right? Politicians turn up, apologize, say there's going to be an investigation, etc., etc. So there is something about the sharp edge of harm that can be revolutionary in itself, but that's not much good to people who are currently dying. And so I think that's okay if you don't want to be part of it. That's fine. But we're doing our thing. Now, you might say that's the flight to regionalism, but I think that Julio's made a really good point that has value, but it's not enough in itself. But we'll take it. But listen, we're just going to do our thing. And if you're not party, that's okay. And so there is this, my bigger concern about the Trump administration is the withdrawal of funding for initiatives that are probably very helpful in disasters and regarding health issues. So just that cutting of funding was resulting in organizations closing down within a week with no support. I would see that as much more concerning to the success, if you like, of these legal initiatives if there's no one there to operationalize it because funding has been withdrawn. That, I think, is really, really concerning. And that means that, some other deep pockets are going to perhaps have to step up. And that, I think, that's going to be a hard one in the face of rampant nationalism. But I think the treaty tends on a positive. I think, and who knows, he could change his mind tomorrow. So, who knows?
Yeah, Julio, did you want to add anything further on that? Or I'll go to another question. Yeah. Well, Kees van Happeren, to move on to a new theme, he wants to know what active involvement has there been from Global South scholars in the development of the International Disaster Law Treaty and the Pandemic Agreement as well. Anybody wants to talk about the role of the Global South and Global South scholars, their inclusion in this?
Yeah. Well, basically, from my understanding, there not be so much. Well, it depends. So basically, in terms of engagement by states as for the disaster, we should already pay attention that there was a quite significant push from the Philippines in the recent years to basically host the conference itself. So already the idea to host a conference in a specific state rather than having it within one of the UN premises, and of course the New York would have been the most suitable venue to take into account how all the discussion was carried out within the sixth committee. Then, on the contrary, there was finally the support by the Philippines to host the conference. At a certain point, there were some discussion whether there could be a second state as a cost. But finally, also I think also for financial reason, the Philippines easily won this bid for hosting the conference. So already this identify how in Asia a disaster-prone country would be glad to host an international conference in this regard, which of course might also have an impact for other states that basically also in political terms, it would be a backlash whether states finally would not support a treaty which is supported by a leading state in Asia. Also, each state usually has a group of states which are more connected to it. The core group of states which was behind the disaster treaty was not very numerous, but it has a quite good geographic representation because it includes as a key player Colombia, plus there was Bahamas, Nigeria, for instance, Italy as well. It's basically the two main players, to be honest, were Colombia and Italy. But then also the other states were quite supportive of that. And Thailand as well was a key player. So you see there was a combination of some states, not with a specific geographical area, as probably the point was that such issues are of general concern. At the same time, I noticed in the past year a quite significant, some quite significant holes in the participation. Pacific states are not a key player were not a key player in the past discussion. They hardly had a clear agenda or hardly intervene very often during the past session. Let's see whether they might have a bit more active role later on. I was recently part of a sort of a meeting of the legal advisor for the Pacific Island states and for the alliance of small island states. You know, there is this other cross-border group. So hopefully they might start to take a bit more leadership role. Africa, honestly, has not yet expressed a strong voice on that, which is, of course, a further element of concern, while on the contrary, Latin America or Southern America and Caribbean, they're fully on board. They were, I would say, the most pushing regional actors in the process itself. In terms of scholars, unfortunately, the situation was worse, to be honest. It's very hard to find experts or scholars with a specific interest in disaster law from an international law perspective. So there are, of course, excellent scholars, a bit more with a perspective on disaster management or national legislation, so far and so on, in the global south, but it's hard to have their voices heard, even if, of course, there are some experts in this area which have provided some support. But in general terms, unfortunately, I've not noticed a big number of scholars from such a region to take a leading role in this regard, also maybe with events, panel in a regional association, like could be the ASEAN Society of International Law, the African Society of International Law, which might reflect how there is no a big scholarly community on that, which of course is a pity, as everyone would be more than happy to hear their voices on board.
If I can just say that I think that this is a clear case for interdisciplinarity, because I think that there is a gap from the Global South scholarship in terms of legal research, but I think that in other disciplines that there is sort of interesting, very important work going on, and I think that therefore that the relevance of that work, the importance of that work, combined with the involvement of civil society, is very like the human rights model really has to be, is in a sense our responsibility to be pulling that forward and highlighting the relevancy. Because if we're struggling to get a big community in the global north, with probably fewer competing priorities than the global south, then I think that is something that we're going to have to look to encourage, almost solicit from those societies. And I know Giulio does excellent outreach work, so that's absolutely no comment on the brave efforts that are being made there. But I do think that there is other work, particularly in geography, as Giulio has said, disaster management, all of those, engineering, lots of work being done in engineering that I've been approached about from Brazil and things like that. So I think that there is work there, but it's not legal. And I guess that's what we're trying to do is bring that forward. So there might be some work that we'll have to do to cultivate and really highlight how we want to hear those voices and how they are valuable.
Brilliant. Thank you, Therese. I think that's a fabulous note to end on. We are just out of time, I'm afraid. But there are a couple of other questions. I will respond to those people in writing and I'll circulate them to the speakers. It's very interesting questions indeed. Congratulations to Therese, Steph, and everyone involved in this project. I'm very optimistic and hopeful that this initiative is going to help to foster this epistemic community of experts and stakeholders from global health and international disaster law to learn lessons from each other. And I hope that the findings and the recommendations that we've developed here, including some of these, hard-hitting and practical political lessons that Mark and Julio have taken us through as well, will be of help to the negotiators of the new treaty and other stakeholders involved in influencing it. So thank you so much indeed, everybody. And this recording will be made available on the event webpage, along with the policy brief with the key takeaways. So do please consult it. Thank you very much.
Thank you.